Erev Tov Rabotai, we are continuing with our Mishna Yomi, Masechet Sanhedrin. We are up to Perek Bet Mishnah Hey. Today's Mishnayot should be Le'elui Nishmat Neria ben Svetlana Ranbai V'Eliyahu ben Burcha Israelov Chana bad Miriam Sason ben Raya and Yoshua ben Shifra Menuchatam Began Eden Amen and Avdil ben Chaim Lechaim V'Derefua Shelemav Daniel Shalom ben Rosa Betoch Shachol Israel and Achlama Merav Binyamin O Tzion Chai ben Dvorah. The Mishnah lists restrictions placed upon the people so that they will not lose their respect for the king. En rochvin al suso, no one besides the king may ride on his horse. Ven yoshvin al kiso, and no one besides the king may sit on his throne. Ven mishtamishin bisharvito, and no one besides the king may use his scepter. If people other than the king would use his articles, this would detract from the sense of awe the nation must have for him. The same prohibition applies to wearing the king's crown or using any of his utensils. It is also forbidden to use his servants. Then no one may look at him when his hair is being cut. No one except the barber himself may see the king when his hair is being cut, because a person in the midst of having his hair cut looks unseemly. Or when he is undressed, or when he is in the bathhouse, even though it is normal to be undressed there. However, his attendants may serve him in the bathhouse. Now, these things all detract from the honor of the king and are therefore prohibited. Shenemar, as it is stated in the book of Devarim, chapter 17, verse 15, Som tasim alecha melech, you shall surely place upon yourselves a king, sheteh emato alecha, which implies that the awe of the king must be upon you. And that is then of Perek Bet Mishnah Hey. We continue with Perek Gimel Mishnah Aleph. The first chapter of this Masechet listed the sizes of courts needed to judge different types of cases. Because that chapter mentioned the Kohen Gadol, the second chapter went on to discuss other laws of the Kohen Gadol as well as another leader of the people, the king. This Mishnah returns to the subject of the first chapter. It begins by quoting the chapter's opening statement. Dineh mamonot bishlosha, monetary cases are judged by a court of three. How were the three judges chosen? One litigant selects one judge for himself, and the other litigant selects one judge for himself. And the two litigants together select one more judge for themselves. These are the words of Rabbi Meir. Now, a judge who is chosen by a litigant will make sure to fully understand the position of that litigant. He will do his best to find all the arguments, laws, and facts that support the litigant, and he will raise them before the court. The second judge will do the same for the litigant who chose him. In this way, no point that could support either litigant will be overlooked. The third judge listens to the discussion between the first two judges and decides which one is right. This is the best method to make sure that the correct verdict is reached. A litigant who uses the system will accept the verdict even if it goes against him, because he will feel confident that every possible effort was made to support him. Now, this system is used when the defendant is willing to be tried but refuses to go before any other court. If, however, he refuses to go to trial at all, the claimant can force him to appear before any court of three judges or before a single expert judge. Again, these are the words of Rabbi Meir. But the sages say, it is not the litigants, but the first two judges who select one more judge for them. If the two judges select a third judge on their own without the involvement of the litigants, the third judge is less likely to lean toward either litigant. The previous Tana, Rabbi Meir, agrees that the third judge is selected by the other two judges because they must consider him worthy of serving on the court with them. The dispute concerns only the involvement of the litigants. Rabbi Meir holds that litigants also have a say in selecting the third judge, while the sages hold that the selection is made entirely by the first two judges and not by the litigants at all. And the Rab tells us that the Chaf follows the opinion of the Chachamim. Another dispute between Rabbi Meir and the sages about the selection of judges. Ze posel dayano shel ze veze posel dayano shel ze, div Rabbi Meir. One litigant can disqualify, meaning refuse to accept the judge selected by the other litigant, and the other litigant can disqualify the judge selected by the first litigant. These are the words of Rabbi Meir. Rabbi Meir allows the litigant to reject only a certain type of judge, namely one who is not fully knowledgeable in the law, but whom the public has accepted and authorized to serve as the judge in their community. A regular judge, however, cannot be rejected even according to Rabbi Meir. But the sages say, Ematai, when can a litigant disqualify a judge? When he brings proof that the judges are related to each other or to one of the litigants, or that they are otherwise ineligible to serve on the court. But if they are eligible to try this case, or if they are experts, a litigant cannot disqualify them from hearing his case. The sage's words should be understood to mean, but if they are eligible, they must be treated like experts, meaning if the judge is eligible, he is not a relative or otherwise disqualified, he cannot be rejected, just as an expert cannot be rejected. According to the sages, since the judge was appointed by the public, a litigant cannot simply refuse to accept him. The only way to have him removed is to prove that he is ineligible or disqualified. Now, Rabbi Meir and the sages disagree whether in a particular set of circumstances a litigant can disqualify witnesses brought by his opponent. One litigant can disqualify witnesses brought by the other litigant, and the other litigant can disqualify witnesses brought by the first litigant. These are the words of Rabbi Meir. This ruling applies in a specific case where one litigant said that two groups of witnesses will come to court and testify for him, even though only one group is necessary. After the first group of witnesses appeared in court, the second litigant, together with another man, testified that those witnesses are disqualified because, for example, they are related to each other. In this situation, even if the second litigant succeeds in disqualifying the first witnesses, he will not win the case because another group of witnesses are coming to testify against him. Since the second litigant has nothing to gain from disqualifying the first witnesses, his testimony against them is believed. Rabbi Meir holds that since the first litigant claimed to have two groups of witnesses, he must make good on his words and bring both groups to court. If he does not bring the second group, the credibility of the witnesses that he did bring is called into question, and he loses the case outright. Therefore, it does not make a difference whether the first witnesses are disqualified, because everything depends on his second witnesses. If he brings the second witnesses, he can win, and if he does not, he will surely lose. His opponent, therefore, would not be biased against the first witnesses, and so his testimony against them is accepted. The sages disagree, but the sages say, one litigant disqualify the witnesses of the other when he brings proof besides his own testimony that they are related to each other or to one of the litigants, or that they are otherwise ineligible to testify. But if they are eligible to testify, he cannot disqualify them to his own testimony, since even in the case presented earlier, it's possible for him to gain from disqualifying the witnesses. He might be biased against them, and his testimony is therefore rejected. According to the sages, a litigant is never required to bring more than one group of witnesses. Even if he said that he has two groups and then brought only one, the group that he does bring does not lose its credibility. In the Mishnah's case, therefore, even if he fails to bring the second group, he could win based on the first group alone. Since the verdict could very well depend on the first group, his opponent may be biased against those witnesses, so his testimony against them is invalid. Rabbi Meir and the sages disagree only in this particular case, where a litigant said that he has two groups of witnesses. If he does not claim to have a second group, his opponent certainly cannot disqualify the witnesses that do come, because the verdict depends entirely on them, as the Gemara explains in Sanhedrin, page 23b. And the Rav tells us the halakha follows the opinion of the Chachamim. And that is an Abotai of today's Mishna Yomi. Baruch Adonai Le'olam. Amen v'amen.